This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are on the state's case of the Delphi trial, Indiana versus Richard Allen. Today, we are going to be talking or reading through the transcript of two more correctional officers. So if you've been following along, most recently we read through the warden's transcript and a bunch of different correctional officers. The Nick McLeland, the attorney for the state, has apparently decided every single correctional officer needs to come in because they need to talk about all these supposed confessions that they got, which incidentally leads me to my next topic. So hold that thought. So today we're going to be talking or reading through Raymond Smith's testimony and also a Jason Bedwell's testimony. And then at the very end, we're going to listen to a little bit of argument. And then next week, we will have finally, we're getting to Dr. Walla. So, Dr. Walla, if you're aware or not aware, she is the psychologist that was treating Rick Allen in the Westville Correctional Facility. She's also a huge true crime fan, apparently, and was in a ton of different discussion groups and groups on social media where she could talk about the Delphi case and learn about the Delphi case through other people. And yet she was also simultaneously treating Rick Allen in prison at that time, which is, huge conflict of interest. Not to mention the fact that around the same time, this is when he starts confessing, and those confessions also coincide with the timing of when he's being given psychedelic drugs of Halidol, huge doses of Halidol, where he's just drugged out of his mind, eating his own feces. So that's how drugged out he is. So this is a good tie-in, I want to say, to the uh, episode that I just recorded last night, which is it's a members only series, but I'm giving you guys the first episode as a public episode so everybody can get a little taste about what the series is going to be about. So the first episode of the series is titled something about the read technique. I can't remember the title. It's about the read technique, which is what officers use to basically coerce confessions out of people. It was so effective that even innocent people confess to crimes that they didn't commit. So, but in that episode, I talk about the fact that the CIA created serial killers. The CIA invented mind control techniques, the MK Ultra stuff that they were I don't know if they invented it, but they were using it on all sorts of people back in the 70s, including Charlie Manson. They created him. There are tons of books about this, and I can't remember. You know what? I'm going to see if I can find it. It's something about the Laurel Cannon. Hold on. I'm going to tell you. It's in my Audible. It's really good. It tells you about how the CIA created serial killers and stuff, and created Hollywood. By the way, all of our people in Hollywood are just fake. If you didn't know. Where was it? I don't see it. All right, I found it, and no wonder I couldn't find it because it's titled "Weird Scenes Inside the Canyon," and then subtitle is "Laurel Canyon: Covert Ops and the Dark Heart of the Hippie Dream." It's an excellent book. I actually listened to it on my audiobooks, and it talks about all the things that I just said. So that's a really good one. And another one is, and that, oh, who just lost it again. Um, I was going to tell you the author, but now I can't find it. Ah, I found it. Okay, it's David McGowan. So David McGowan, Weird Scenes Inside the Canyon, excellent book. And then the other book that I would recommend is Chaos by Tom O'Neill. That's another good book that also talks about how the CIA created Hollywood and um, serial killers. So, what I my point in bringing that up is that those mind control techniques are what our officers are using to get coerced confessions. Similar techniques, not necessarily all the same, but in the same line of mind control techniques. And that's how you're trying to get it. The point of the read technique is you already go in as the officer going in to question someone, you already think that they're guilty, which, as you know, we are all presumed innocent in the court of law. So it kind of works backwards when law enforcement is doing their investigation, and it really shouldn't. But my point is that I really believe that Richard Allen was subjected to some mind control techniques, especially under the Halidol. And I think Dr. Walla might have been a part of that, including some of these correctional officers and including the warden and maybe others. Maybe Holman and Mullen and, some of the key investigators in this might have had something to do with it too. I don't know. It would be interesting to see if they ever visited Richard Allen. So that's my little uh, thing to plug. First of all, Debunked and Dissected. The first episode is out on the Read Technique and it is public to all. So go watch that if you're interested. And let us begin. So here we are. Am I big enough? Yeah, I think so. All right. So we're going to begin the direct examination of Raymond Smith. All right, Nick McClellan says, Officer, before we get started, I'm going to ask you, he's going to ask him to speak up. He says, use your best outside voice when you're testifying. I've already struggled today to hear the witnesses. Unfortunately, that microphone does not amplify for us inside the well or in front of the bar. It only amplifies for the audience. I have to be able to hear you. The defense has to be able to hear you. The judge has to be able to hear you. And most importantly, the jury. So if you could just speak up and use your best voice. To be a lawyer, do you have to use mm, the most amount of words as possible to speak? Because I feel like sometimes you could have succinctly said that. Anyways, I promise you won't be yelling, but just all you need to do, we all need to be able to hear you clearly. Fair enough? The witness says, yes, sir. Yeah, you don't need to lean into the microphone. She's recording, so just sit back and we'll ask you some questions, okay? Okay. All right. Will you state your name, please? My name is Raymond Smith. And will you spell your last name for me, please? And he does. And how are you employed? I'm employed as a corrections officer at Westville Correctional Facility. And how long have you been employed there? Over 6 years. Before you became a correctional officer, you go through any kind of special training or schooling to become a correctional officer? I went through 8 weeks of training at the facility. And what shift do you work at Westville? I work the night shift. It's called K Group. It's one of the two night shifts. And can you tell me the hours that you work? 6 p.m. to 6 a.m. And do you work in a specific unit within the facility at Westville? Yes, it's referred to as segregation. Is it also referred to as the WCU? It is. Okay, and are you familiar with an individual by the name of Richard Allen? Yes, I am. And how are you familiar? He was an inmate in that WCU where I work. And at some point during his stay at that facility, were you asked to be his companion, his watch companion for him? Yes, I was. And did you entail did that entail you sitting in his cell and recording his statements and his actions? Yes, it did. And did you do that on a consistent basis? Yes. And did you do that consistently each shift you worked? Yes. I'm going to show you what's been marked as States Exhibit 299. Does this document look familiar to you? Yes. And what is it? It's a companion watch report. And are you familiar with these reports? Yes. I can't say this word on YouTube, so I'm going to skip over it so you know. And yeah, but it is just so you know, he was under 24-hour surveillance. Even though he was in a cell that had a camera recording him, he also had to have someone sitting outside of his cell watching him 24/7 for some reason. I don't know. Are you familiar with these reports? Yes. And are these reports that you would take as part of your duties as a companion? Yes. And who is the author of these reports? Myself. How do you know that? It's in my handwriting. It has my initials and name. Mr. McClellan says, Judge, the state would move to admit what's been marked as State's Exhibit 299, please. No objection, says Mr. Rosie. The court says, all right, I'll show it's admitted without objection. Mr. McClellan says, Judge, may I follow the same procedure by publishing it to the jury so they can follow along? You may, says the court. Thank you, says McClelland. She says, you may proceed after it's published. Mr. McClelland says, thank you, Judge. Officer Smith, I want to draw your attention to the first page of that document, which is April 10th of 2023, and I want to draw your attention to 3:24 a.m. on that date and time. What did Mr. Allen say? Mr. Allen, at 3:24 a.m., licked the window of his door and stated, Kathy, I did it. I'm guilty. Run, Kathy, run. I did it. Does not sound like someone in their own right state of mind. Then I want to move on to the next sheet on April 22nd. Want to draw your attention to 7:55. What did he say during that time? Let's see. At 7:57 p.m., he stated, I killed those two girls, so I have to kill myself. Mr. McClellan says, I don't have any other questions, Judge. The court says, Mr. Rosie. Mr. Rosie says, thank you. So now we have cross. And Mr. Rosie says, so I'm sorry, do you still work at the DOC? Yes. Okay. And you've been there for 5 years, you said? Over 6. And you were interviewed by law enforcement officials back on August 8th of 2023 at the prison? That's correct, yes. You read your statement before you came in here today? I did. And Rick told you that if he fucked those girls, he fucked them is what he said to you, didn't he? If that's what's on my statement, yes, I believe he said that. I would have you refer to my statement. Would it help you to look at your statement and refresh your recollection? Yes, it would. Mr. Rosie says, okay, may I approach, Your Honor? You may. Direct your attention to page 13, lines 9 through 11. Let me know when you've read those. Did you look at that? Yes, I do remember him saying this. Did he say this to you? If I fucked those girls, I fucked them. If I killed them, I killed them. He did. He repeated that a couple times to you? Yes. To me, that sounds like someone's like, well, I don't believe I did it, but if I did it, I did it. Like trying to convince himself, you know, because he's not in his right state of mind. Mr. McClellan says, Judge, I'd ask the witness to be allowed to read the entire statement to put it in context. Mr. Rosie paraphrased it incorrectly. That's not what his statement says, so I'd ask the witness to be allowed to read that entire answer into the record. Mr. Rosie says, that's fine with me. Well, what lines do you want him to read? I guess just so that's the whole page. Mr. McClellan says lines 15 through 21. Mr. Rosie says, well, he said it in lines 9 through 11 for starters. Mr. McClellan says, okay, he says it in two places. So I'm okay with him. I guess I could follow up with some questions, Judge, but he says it in two places, and I'd just like to put it in context, but I can follow up with my own questions on redirect, Judge. The court says, you may continue, Mr. Rosie. Did you report that? Did you report that you thought he was having some trouble remembering, maybe? I just wrote down what I heard him say. I don't know what his mental state was. I don't know if he was having trouble with memory or not. Or maybe if he was saying it, he was saying it like it didn't matter, right? That's possible. So you weren't really sure of the context. No. Now, going back to your log sheet, Exhibit 299, which you've got there on your desk next to you, directing your attention to the April 10th entry at 2:50. You see that? The very first entry? Yes. So this is at 2:50 in the morning, right? Correct. When most people would be sleeping, right? Right. And he's awake and he's singing God Bless America, correct? That is correct. And at 3:12 he starts masturbating in front of his door, right? That's correct. Singing Mamas Don't Let Your Babies Grow Up to Be Cowboys? Yes, sir. This is going on at 3 in the morning? Yes. And then you said earlier he started licking the door, the window of his door, right? That's correct. Then at 3:35, want to direct your attention to that entry back to God Bless America, I'm guilty? Yes. Directing your attention to April 10th, 2023, entry at 4:05 to 4:11. Do you see that? Yes, I see it. So is he running now in place and singing God Bless America? Yes. I mean, I'm just trying to envision. It's like you would do if you were at a football practice or something. Yes, sir. Does anybody report any of these did anybody report this on this night to somebody like a mental health provider or I recorded it in my log? Well, is that reporting it to a mental health provider? No, sir. He says there's no mental health provider until early in the AM, a few hours after this was reported. Sorry. So, because it was 3, 4 in the morning, obviously the mental health person isn't there yet. Probably comes in at like 8. So, yeah. So April 10th at 4:50 a.m. Do you see that entry? Third one from the bottom? Yes. Did he tell you, I want to go camping? You, me, Roger, and Mervyn? Chris is my best friend? Yes, that's correct. Did any of this make sense to you? No. And then at 5:17, he starts talking about his wife, right? Mentioning his wife, Kathy? Yes. There wasn't any time when you were watching Richard Allen that he mentioned any details about killing those girls, is there? Not any details that aren't recorded in my report. Fair enough. Basically, just the references to the sex acts, right? The references that are on my report. Okay, and you said that as of August, when you were interviewed on August 8th, that you described him as being polite at that point, right? That's correct, yes. You noted that he slept a lot, far more than other offenders. Yes, which he would do if he was on Hal. You also noted that there wasn't much in his cell. It was pretty bare. That's correct. Wasn't a real stimulating environment, right? No. And the last time you ever heard him say anything about his case was back in April of 2023, maybe early June, I think you actually said? Yeah, in that time frame, yes. But definitely not in July. No. That's what you said? Yes. And you said that the other offenders would go at him, right? Other offenders would attempt to agitate him. And they would say to him, there's no insanity defense. That's correct. They would say some of that. Mr. Rosie says, I don't have anything further. The court says, Mr. McClelland, thank you, Judge. Now we have a redirect of Raymond Smith. Mr. McClelland asks, During the interview that Mr. Rosie asked you about where he made those statements, you gave the officers some additional information as well. Is that correct? The officers that were interviewing you? I would have to refer to it. I believe that. Do you still have the document? This document? Yep, that's it. Yes. I'd refer you to page 13 and I would draw your attention to lines 11 through 13. Let me know when you've had a chance to review those. Yes, I remember this. So you talked about what you heard Mr. Allen say about having sex with the girls. He also talked about if he killed them, I killed them. Is that correct? That's correct. And then what other explanation do you give the officers that day for those, what other explanation do you give the officers that day for those statements? I stated he seemed like he was having trouble remembering. Like either he was having trouble remembering or he was almost saying it doesn't matter. What kind of behavior from an inmate in a cell would require you to notify a mental health professional immediately? Any type of behavior that would indicate the inmate is about to attempt self-unaliving. Any behavior that Mr. Rosie went over with you that Richard Allen was displaying in his cell, did any of the behavior cause you to notify mental health immediately? Not immediately, no. He did state that I'm paraphrasing because I don't have it in front of me. He killed those girls, so he needs to kill himself. I had I had him under close observation at that point, and if he had done anything, I would have. It would be or would have immediately been acted upon to stop it. So only if he's attempting self harm himself, to harm himself is a better way to say that. Um, so only if he's harming himself is it worth getting mental health professional in. It doesn't matter that he's eating feces and he's running and slamming his head into the wall and doing things like that are dangerous to himself and can hurt him, but yet only if he's attempting to take his own life. He can hurt himself all he wants. That's fine. It, the policies here and the way that this inmate, whether you believe he did it or not, is atrocious. And there's no other way to put it, but state sanctioned torture. That's what it was that he had to endure. The original judge before Judge Gall, Judge Diener, approved a safekeeping order. Say that 10 times fast. Safekeeping order. And so with that, he was put not in jail, like a county jail, which is where he should have been awaiting trial. They put him in a prison with all these convicted offenders. But because he was with convicted offenders and he was accused of this crime of hurting young children, they put him in a segregation for 13 months. He was in solitary confinement. The cell being watched though 24/7 by these people. But that would make anybody go crazy. Whether you were crazy to begin with or not, you would come out of there crazy. But even in that statement, you didn't notify mental health immediately because you were there to watch him. Right. We don't really have the capability to notify mental health immediately. You have a nurse on the night shift, usually an RN, and we have supervisors in the custody staff. I could have notified them. I don't remember if I did or not. Okay. The nurse was not notified. Okay. I don't have any other questions, Judge. Thank you. He kind of shuts him off because it's not good that you didn't notify anybody. The court throws it back to Mr. Rosie, and he asks the witness. On April 10th, were these the first page of the entries were made on April 10th, right? Correct. And this conversation that Mr. McLeland just had with you was during that time frame? Right. Yes. At that point, he was on this self-unaliving watch, wasn't he? Correct. His cell was stripped down to almost nothing, wasn't it? Yes. I mean, really, we're talking about a concrete cell with a little mattress in the corner, pretty much, aren't we? Yes. Not even any sheets in there, are there? No. A steel toilet? Yes. Bolted into the wall? Correct. With a sink sitting right on top of it? Yes. Basically, brush your teeth right over your commode, don't you? That's correct, yes. I don't have anything further. The court says, does anybody or on the jury have any questions for Mr. Smith? No response or indication from the jury. And the court says, all right, thank you, sir. You may step down and I can take that. Oh, wait, I'm sorry. There is a question. So we do have a question from the jury. The court reads in a sidebar, what are the self-unaliving actions that require calling the doctor? Mr. Rosie says, okay, good. The court says, who is MM? Mr. Rosie says, MM is the officer Moneypenny listed at 7:55. I don't know what that means, the court says. He's probably on one of the logs, says Mr. Rosie. Mr. McLeland says he's on one of the logs. Mr. Rosie says his entries are on here. Court says, oh, okay. Mr. McLeland says, I'm okay with that question. The court says, so who is MM? McLeland says, it's Mike Moneypenny. Court says, oh, the officer Moneypenny. McLeland says, yes. That's listed and is him? Yes, that's him. So I can just keep it as MM and he'll know what I'm talking about? Yeah, that's fine. Okay. Then you have one more witness. Can I tell them that there's one more witness? Mr. Rosie says, yeah, yeah. Mr. McGlynn says, and don't think it'll be a long one. So the court says, okay, just so that they know uh, that we're going to go, just so they know we're not going to go on indefinitely. Mr. Rosie says something inaudible till midnight. The court says, okay. Sidebar concluded. Now the court asks in front of the jury, Officer Smith, what are the self-unaliving actions that require calling the doctor? The witness says, a physical act of attempting self-unaliving will be acted upon. Any actions, such as him saying that he would kill himself, is reported in my log and can be seen by mental health professionals the next morning. Court asks, any follow-up, Mr. McLeland? No, Your Honor. Then the court says, Mr. Rosie? No, ma'am. And on the log, if you could just look at that again, sir. Who is MM, the officer listed as at 7:55 p.m.? MM is, I believe his first name is Mark, and that would be Moneypenny. His last name is Moneypenny. Any follow-up? No, Your Honor, says McLeland. The court says, Mr. Rosie says, no, ma'am. Court says, all right, thank you, officer. You may step down, and I'll take that. And ladies and gentlemen, we have one witness left for the day. I just want you to know we're not going to go on forever. We have one witness left, and then we're going to recess. You may call the next witness of the day. Mr. McLeland says, thank you, Your Honor. The state of Indiana would call Officer Jason Bedwell, please. And we begin the direct examination of Jason Bedwell. Mr. McLeland says, Mr. Bedwell, I'm sure the jury and the court's tired of hearing me say this. I'm tired of hearing him say it. But I'm going to say it again. I want you to speak up as best you can. Use your best outside voice. I'm really struggling to hear people this afternoon. That microphone doesn't amplify for us, so if you could just use your best outside voice so everybody could hear you, we'd appreciate it. Fair enough? Yes, sir. Perfect. Will you state your name, please? Jason Bedwell. And will you spell your last name for me? He does. How are you employed? I am a custody officer at Wabash Valley Correctional. Okay, so he's with Wabash, not Westville. My bad. I think I put on the thumbnail that they were both from Westville, but he's from Wabash. So if you recall, after the safekeeping order it was held in place so long by this other judge for no reason. He didn't need to remain in solitary for 13 months by this Judge Diener. And then the case got transferred or moved to Judge Gull because Judge Diener recused himself for reasons we don't know why. And then finally, after Baldwin and Rosie were kicked off the case by Gull and then they came back on the case, they were able to get him moved to the Wabash facility. So he started off in Westville. Wabash is also, though, a prison for convicted felons as opposed to a county jail again. So he's still going to uh, prison for convicted felons, convicted inmates. And how long have you been employed in that position? 9 years. And before you became a correctional officer at Wabash Valley Correctional Facility, did you go through any kind of training to become a correctional officer? Yes, sir. Can you tell me about that? I went through training for facility security, inmate transportation, and CTS training, which is what's called Certified Treatment Specialist to work with the mentally ill inmates. And what shift do you work at that facility? Day shift, H bracket. Could you tell me the time periods of that shift? Time period is from 6 a.m. to 6 p.m. And you may already have stated this, but do you work in a specific unit within that facility? I have worked many different units while I've been there, but at the time I was working at the secured correctional unit on the confinement unit, which is also known as the something something because it's inaudible, we won't know. Are you familiar with an individual by the name of Richard Allen? I do. Shouldn't it be I am? How are you familiar with him? I was doing a watch sheet, and basically, I was watching over him throughout the day to make sure his mental health, his physical health, and well being were doing okay. And when you watch over him, this may be a silly question, but are you at his cell watching him? At his at that time, I was doing a 15-minute walk, 15-minute round. So no, I wasn't there all day. I walked out. I'd observe, see what he was doing. I would walk back to see where I was, and I would log it down on the flow sheet. So he didn't even log it in real time. He would log it later after he did his rounds. How much time did you spend at his cell when you were observing him? Enough time to see what he was doing, enough time to understand what he was doing, what was going on. Now, if there was something else that was going through that would be more concerning to me, on there to where I needed to look, what? I'd be there a little bit longer. Was that English? And so every 15 minutes, you'd go down to his cell and look into the cell to observe him? That is correct. And you observed him for a few minutes and then returned to your duty station? That is correct. Unless something was going on and you observed, you would observe longer? That is correct. Is that a fair summary of how you watched? Yes, sir. Richard Allen? Yes, sir. I want to show you what's been marked as State's Exhibit 300. Can you tell me, well, first of all, are you familiar with this document? I am, sir. And what is this document? This is the offender flow sheet, watch sheet for watching as we would call the self-unaliving watch. And is this the sheet that you log any activity on when you observe Mr. Allen? It is, sir. And is that a sheet that's necessary to coincide with you watching him? It is, sir. And who's the author of this sheet, meaning who filled this sheet out? I did, sir. How do you know that? Because my initials are on the left-hand side. Also, if you take a look at the bottom, is there some identifying information that let you know who filled this form out? There is, sir. My initials are on the bottom along with my name and title duty. Mr. McClellan says, Judge, the state would move to admit what's been marked as State's Exhibit 300 into evidence. Mr. Rosie says no objection. The court says all right, without objection, 300 is admitted. Mr. McClellan says, for the last time today, if I could follow the same procedure of publishing it to the jury. The court says you may. It is published. The court says you may proceed. Mr. McClellan says, thank you, Your Honor. Officer Bedwell, what date was this sheet drafted on? Drafted on February 4th, 2024. And I want to draw your attention to 10 a.m. on that day. You see that entry? Yes, sir, I do. Is that marked with your initials? It is, sir. And at that time and date, what did you hear Mr. Allen say? At that time and date, I went there and walked down at around 1,000 hours. Is that how you say that? I don't know how you say that. That Mr. Allen was in his cell and I overheard him saying that I am sorry for what I did. I'm sorry for killing those girls. And you have the designation under offender behavior as 2-6. Can you tell the jury what that means? A 2 over there is the offender behavior. Number 2 is where he was lying down and he was crying. He was awake at the time. And number 6 is that he was talking to himself. I have no other questions, Your Honor. Mr. Rosie, says the judge. Mr. Rosie says, thank you, Your Honor. And we begin cross-examination of Jason Bedwell. All right. I don't know what happened. My mic went out on me, so I hope you guys heard whatever I was saying in my last sentence. I had to restart my whole computer and everything because whatever, it was being annoying. So we left off here where I highlighted, which says 9 years. So how long have you been at Wabash Valley? 9 years. And you were assigned to monitor Rick Allen's words and actions down there? That is correct, sir. Maximum security. Solitary confinement unit? That is correct, sir. It's kind of a unit within a unit down there, right? It is, sir. 8 by 12 cell, roughly? Roughly, sir. This is the first time we're hearing about what this cell was like, 'cause I don't remember ever hearing what his cell was like or his conditions were like in Wabash. Concrete walls, steel door, steel toilet? Yes, sir. Isolated from all others. Isolated from all others? Yeah. No, sir. He didn't get to have any contact with other inmates, does he? No. There is no other contact between others except if he does speak through the wall with some of the others. That's not contact, you moron. They can yell at each other through the walls and the doors. They can. You watched him from late January to early February of this year. I'm sorry, sir? You watched him from late January to early February of this year. I watched him from February to said date. And this log, number 300, exhibit number 300, reflects that he pretty much was laying down the entire time between 6 a.m. and noon, right? For the most part? For the most part, sir. That's what number 2 is, right? That is correct, sir. And you make those codes on the door sheets kind of in real time. Is that fair? That is correct, sir. And you agree that he did a lot of laying down and sleeping when you were down there. He did a lot of laying down, sleeping. He was up during chow movement. He'd go back, he'd sit down by the bunk. Other than that, yeah, there was nothing much else. Well, what is there to do anyways? But you did make a note, for example, at 900 hours, 9 a.m., that he was taking his medication? That is correct. And you made a note specifically that at 6:30 in the morning he was eating and drinking. That is correct. One second, I'm looking at the street here. So on February 4th, you noted at 10 a.m. that you overheard him say he was sorry for taking the girls' lives, right? That's correct. And you made a note that he was laying down awake, right? That's correct. And number 6, that is, he was talking to himself? That is correct. And this whole log sheet over here on the right has kind of the key here where you can, determine what the behavior is and then essentially code it over here on the left. That is correct. supposed to be real easy for you because it's all here on the page, right? That is correct. And the idea behind this is so that you're as accurate as possible when you report this stuff, right? And that is correct. And there's as much detail as possible. That is correct. And you were interviewed by the police about a month and a couple weeks later, March 15th, 2024, weren't you? That is correct. And at that interview, you provided them with a little different version of what you have here on this log sheet, didn't you? I gave them exact what I told them on there, sir. Okay. Well, you told the police that Rick Allen was actually curled up in a fetal position. Mr. McLeland says, I object. Is he trying to impeach the witness at this point? The court says, I'm not sure. Are you trying to impeach? Mr. Rosie says, yeah. McLeland says, that's not the proper way to do it then. You need to give him the document, refresh his recollection, then you can ask him questions. He's just reading from the document. Mr. Rosie says, I'm asking him right now what he told the police. If he denies that, then I can. The court says that is improper. That is an improper way to impeach. Do it the appropriate way, and you can absolutely impeach him. Mr. Rosie says, thank you, Judge. Did you tell the police that he was curled up in a fetal position? I did. Okay, you didn't note that on this watch sheet, did you? There's no specific way of putting it on the sheet that he was curled up. I put what was on there, what he said, and what he was doing at the time. Okay. You see item 27 there on the right side? Item 27? Yeah. Yes, I do. What's that say? It says other, specify. So that might be one code that you could use to identify that he was curled up in a fetal position, right? At the time, it could be. Okay. Did you tell the police that he was facing the wall on his bunk? I did. But you didn't note that on the sheet, did you? No, I did not. Did you tell the police that his demeanor would change from calm to almost hysterical? I did. You didn't note that on the sheet, did you? No, I did not. In fact, the log sheet shows that at 9:45 he was laying down, right? It does. And actually, when you testified earlier, you said that he was laying down crying, were your words, right? That's what you said a few minutes ago when Mr. McLeland was. He was laying down crying. Okay, well, crying is over here. Let me direct your attention to the key on the right. Crying is number 8, right? It is. Code 8? It is. Where is code 8 referenced on the left side here? On the left side, it is not. I always put down what I observe at the time. Well, you said he was crying, but you didn't note it, right? I did. So at 9:45, he's laying down. There's no other behavior to note, right? No, there's not. And at 10:15, he's laying down and he's talking to himself, right? That is correct. Not much activity before this 10 o'clock entry and not much after, is there? There is not. And in fact, you told the police that he said, I'm sorry for the things I've done. I'm sorry for killing those girls. That's what you told the police. That is correct. That's not what you documented here, is it? I guess not. This is what I corrected on what I said on here. He said he was sorry for the things he'd done and sorry for killing the girls. All right. It says overheard inmate Allen say he was sorry for killing the girls, right? It says that, sir. It doesn't say anything about the things he's done, right? No, it does not. Okay, so when the police got there a month and a half later, you added some facts to all this, right? Objection, judge. Asked and answered. Overruled. You added some facts? Yes. That room is a rectangle, basically, isn't it? Pretty much, sir, yes. And the bunk in that room is on the back wall, isn't it? It is, correct. And Mr. Allen was facing away from you when this occurred? That is correct. You couldn't see his face, right? No, I could not. There's a metal door on the front of that cell? There is, but there is also a window off to the side. Okay. Yeah, actually, there is a window off the side. It's a strip window, isn't it? That is correct. It's actually got a sticker, doesn't it? So you can't see into most of the bottom part? No, it does not. The only time it has anything that is up on that wall, up on there, is when the inmate puts it up there if they were using the restroom. Okay. You don't know in what context he spoke those words, do you? I'm sorry? You don't know in what context he spoke those words, do you? I'm not understanding your question. Well, you didn't hear him say anything before this, right? Before what you reported on the log sheet, right? That is pretty much that's all he said at the time and I was standing there, which was just a really short period of time. It was approximate probably about 10 minutes. Okay, that I stood at the door. So the only words that he uttered in 10 minutes were the words that you note on the sheet, right? Between, yes, between him crying and that's what he said at the time. Plus, the additional words you told the police that he uttered when he talked to them 6 weeks later, when you talked to them 6 weeks later. When you talked to them 6 weeks later. Beside what I told the officer there, yes. So your log entry is not really accurate, is it? The log sheet at the time is just a quick reference of what was going down at the time. A quick reference. Is that what you call for from the side, from the guidelines off to the side and what you put down from to log it in and oh my God, can I talk? Is what you call for from the side, from the guidelines off to the side and what you put down from to log it in and you go right back to sit. I think that's not fully English, but okay. And then you're just sitting there watching the cell for 15 minutes, right? You walk in, you look at the cell, you observe what he's doing, and you go back and you sit down and you log it back in. I feel like these officers might be having some issues with their words sometimes because, like, I feel like some of their answers are word salad. Like that answer that made no sense. You had plenty of time to make full, detailed entry, didn't you? Between that and also helping out my other fellow officers doing insulin checks with the nurse, also doing coming around and helping out with either chow movements at the time, there isn't time between in there where I could do that. Yes. So you said earlier you spent 15 minutes looking at him, right? I said 10. 10 minutes, I'm sorry. Could have could have made a full-blown detailed entry in those 10 minutes, right? I observed what I seen and I observed on there. That's again not really that's word salad. Could you have made a full-blown detail entry in 10 minutes? I observed what I seen and at that time. That's not answering the question. I don't have anything further, says Mr. Rosie. The court says, Mr. McLeland, no questions, Judge. The court says, does anybody on the jury have any questions for Mr. Bedwell? Would counsel approach? So it looks like we do have some questions. The court reads in a sidebar, was the information on the offender watch flow sheet entered and documented in electronic record? Mr. McLeland says, yeah. Mr. Rosie says, sure. The court says, and if so, is there a space for you to elaborate on your observations? Mr. McLeland says, no objection. Mr. Rosie says, no objection. The court says, and did you elaborate? That was the last one, says the court. Mr. Rosie says, yeah, building on each other. The court says, was Richard Allen under video/audio monitoring during this time? Mr. Rosie says, I don't have any objection. So the court says, okay. And don't forget, too, that we're going to hold everybody for a little bit after. Mr. Rosie says, oh, okay. The court says, okay. So you maybe come over here and we have a conversation. So Mr. Rosie says, okay. Sidebar concluded. Now, this is in front of the jury. The court says, Sir, is the information on the offender watch flow sheet entered or documented in electronic form? In an I that I do not know if it is or it is not. I log it, turn it in at the end of the day. Any follow up, Mr. McClelland? No, Your Honor. Mr. Rosie? No. Was Richard Allen under video or audio monitoring during this time? No, he was not. The court says, any follow up, Mr. McClelland? No, Your Honor. Mr. Rosie? No. All right, thank you, sir. You may step down. And uh, Mr. McClelland says to Mr. Bedwell, I'll take that. The court says, oh, thank you. The witness says, thank you. Court says, all right, well, ladies and gentlemen, as I told you, that's the last witness for the day. So again, while you go on about your own business, I know that you'll have access to your phones and electronics so that you can communicate with family and check your work emails under the supervision of the bailiffs, but please don't talk about the case amongst yourselves or with anyone else. Remember, they are sequestered. The jury is sequestered and they do trial Monday through Saturday. Saturday's a half day. Again, just leave all of your materials there and we'll have those available for you tomorrow morning. Please have a safe and peaceful evening. Enjoy your dinner and we'll see you tomorrow, gentlemen. The bailiff says, all rise, and the jury leaves. And we're going to have some arguments here, or arguments, discussion, whatever, between the different, between the lawyers here. Mr. McClelland says, so close, but yet so far. Don't know what that means. They're at a sidebar, FYI. The court says, okay, so we're just going to chat because that lady's still in the courtroom. So I told Jeremy that he knows he needs to let us know when the jury's out. They're taking them outside through the entrance on back. Jeremy, when they get downstairs, will let us know. Jeremy must be the bailiff. Will let us know when he's on the way and driving. So I'm not sure if something inaudible. So, what's the state's perspective as far as tomorrow is concerned? Mr. McClelland says we're going to plan on calling Dr. Walla. The court says, okay. Mr. McClelland says, I'm hopeful that we can get it done in the morning, but I'm not sure. Mr. Rosie says, it's your witness. Miss Diener says, it's your cross. Mr. McClelland says, it's your cross. Ms. Diener says, let's not pretend. Mr. Rosie says, I'm doing my job. Mr. McClelland says, and then Mr. Rosie says, and she gave us a lot to harp on. McClelland says, I think we'll have Officer Harshman at some point, and then we've got to talk about. There was a jury question, and I'd like to call him as a witness about that. However, it wasn't part of discovery. It wasn't It wasn't because we just did it. We did a digital search to see if there were any 2016 Ford Focuses. The court says, oh, okay. So they're looking for Ford Focuses just now. Mr. McClelland says, and we followed up on that. Court says, okay. Mr. McClelland says, so I would call a witness, Steve Mullen, just for documentation, just that certification from that the BMV standpoint, something, something. We'd like to call him something, something. So we may have that witness as well. There's a lot of inaudibles in the sidebars. Maybe they don't want us to know what they're talking about. Mr. Rosie says, well, we've kind of talked about that. The court says, okay, we'll talk, says Rosie. The court says, yeah. Mr. Rosie says, I don't think it's a huge deal either way. Court says, okay, it's not a game changer. Baldwin says, no. Mr. Rosie says, no, well, something, something. You don't know? Mr. Rosie says, something, something. Mr. McClelland says, but I think we're near the ending point, and I think tomorrow I believe we'll call Dr. Walla. Court says, okay. Another inaudible. Mr. McClelland says, we will have phone calls to play through Harshman. We have 2 hours of phone calls, so that'll take some time. Mr. Rosie says, I have a thought. If they finish up on Thursday, would it be... The bailiff says, hey guys, they're still on the record. Mr. Rosie says, oh, because there must have been people talking in the gallery or galley, whatever you call it. And so the bailiff told them to shush. Mr. Rosie says, possible to just go ahead and recess and then let us start on Friday because we are trying to coordinate witnesses because Nick's been kind enough to give us a date of something, and so we're starting to something. I think it would help. Uh, and then the court says, well, I guess it kind of, Mr. Rosie says, if we know that it probably the safest bet is Friday, that's what I'm hearing, that they'll definitely be done by the end of Thursday. Mr. McLeland says, unless something crazy comes. Court says, well, I mean, in all fairness, if they rest at 10, no, I'm not going to until Friday. You're going to be after lunch. So Mr. Rosie says, oh, okay. That's what I'm kind of asking here. Okay. The court says, I mean, you may have some people that you may have to call in out of order. I get that. Mr. Rosie says, yeah, but we're just not gonna, oh, we just, Mr. Baldwin says, well, what about in the afternoon? The court says, oh, 3 or 4 in the afternoon, unless you've got a quick witness that you can put up for a couple of quick witnesses. I'm concerned about their time. They're anxious to get through and get home. You have them sequestered. They got nowhere to be except in a hotel room. Who cares if they go later? I would rather just get it all done and have my days be longer so I don't have to stay for more days. Whatever. She says they're anxious to get through. Ms. Auger says, sure. The court says that would be my concern. Mr. Baldwin says, we're working on it. We'll get you that list by the end of the day. Mr. McLeland says, yeah, if you could get me that. Mr. Rosie says, well, it may. Ms. Auger says, it may change. Mr. Baldwin says, we may narrow it. Mr. McLeland says something that's inaudible. Mr. Rosie does too. The court says, I mean, I don't know if you have a witness that. Mr. Rosie says, yeah, we. Court says, maybe shorter witness. I hate how they just keep interrupting each other. The court says, I don't know if you may have a witness that may be a shorter witness. I don't know how Kathy Allen's going to testify to if there's something shorter. Mr. Rosie says, just fill in the gaps. The court says, yeah, just somebody to fill in the gaps so that we're just utilizing the juror's time. But the most memorable juror or the most memorable witnesses, I think, are like in the beginning and the end. So you want to start off with a good witness with your case, I would think. Mr. Baldwin says, we should know better by tomorrow, I think. The court says, okay, well, then you guys sit down and try to figure it out. And Mr. Rosie says, we were thinking about calling Westcott, but she might take a lot of time, so I don't want to something. I mean, I don't know until we find out are, who they are, what time, something. I don't know. So I think that we would try to get her in. We're dealing with, schedules too. Mr. Baldwin says, yeah, we had a lady that's going to be introduced that's going to be induced labor wise Friday, maybe. Yeah. Mr. Luttrell says something inaudible. Mr. Baldwin says, yeah, we'll have to think about it. I'm sorry. The court says, well, you guys, so you kind of know where my head is at as far as moving. Miss Rosie says, yeah, this is impossible to follow with all these short and everybody cutting off, everybody speaking like these short sentences and everybody cutting everybody off. Court says, okay, and I think all right, we can go back on the record. So the sidebar conference is concluded, thank God, because now they can speak in normal sentences. All right. Well, thank you for the sidebar so that we can kind of get an idea. I've been trying to let the bailiffs know when we start in the morning with what our estimated time frame is. So I appreciate having that information. And I think at this point, the jury is probably out of the building. So is there anything else that we need to do on the record as far as the state is concerned? Ms. Diener? No. Mr. Rosie? No, ma'am. Thank you very much, Jody. We can go off the record, and they do. And then we're going to read a little bit of I think we have some more arguments the next day here. So they go back on the record October 30th, 2024 at 9:08 a.m. The court says, "All right. Well, good morning, ladies and gentlemen. We are back on the record in the state of Indiana versus Richard Allen. I'll show the defendants here in person with counsel states here by their prosecutor and deputies. The jury has reassembled. I apologize for a little bit of a late start. I had a couple of logistical issues I needed to address with the security staff. So, is the state ready to proceed with its next witness? Miss Diener says, Judge, we're wanting to request a sidebar for a few issues regarding our first witness. The court says, okay, and a sidebar is conducted. The court says, no face plants, please, no face plants. Did somebody almost fall the day before when they said that was close? I don't know. It's hard to tell when you can't see what's happening. Ms. Diener says, Judge, Ms. Diener's for the state, in case you forgot. Ms. Diener, Mr. Luttrell, and Mr. McLeland are for the state, and Mr. Baldwin and Mr. Rosie are for Mr. Allen. Ms. Diener says, Judge, if we could, we would like an admonishment, or basically we're asking the court to order an oral motion in limine about impeachment of Dr. Walla. What? She hasn't even started, and they want a motion in limine about impeaching their witness. You already know she's going to be bad. That's a rough start. In the 3-day hearings, there was testimony about an insight search of Keegan Klein. That would violate the motion in limine on both parties. In addition, I anticipate the defense is going to ask her about that, just as they did with Brandon Fisher about him getting fired from the DOC. Dr. Weller was not fired, but she has had a gate closure, and that she went and found a job somewhere else and just left. So she was not terminated. We had a deposition with an employee from the investigative office of the DOC, and they said that they could not do an audit. They had no proof that she had done any sort of insight search on DOC property. Keegan Klein was um, the one who was running a fake profile account, and Libby was talking to that fake profile account, and she was actually talking to him that day, Keegan Klein. And then very shortly after the Delphi homicides, he was caught soliciting undergirls to meet undergirls somewhere or something. I can't remember the specifics, but yeah, so he was arrested after the Delphi trial, or before the Delphi trial, but he was a suspect. I got eye pain for some reason. Shooting eye pain. Where were we? So we had a deposition with an employee from the investigative office of the DOC. They said that they could not do an audit. They had no proof that she had done any sort of insight search on the DOC property, so it went nowhere except a closure. I think it's unfair to bring that up. It's not proper impeachment. Did some research on the case with regard to that issue. The other one was he was safekeeping status. I anticipate they will be asking her about how he became a safekeeper, why he remained a safekeeper. That's not something she, as an employee of Centurion and service provider to the DOC, she's contracted from a different company to work at the DOC. It's not something that she can answer. It was on a legal determination by this court that he was ordered to be a safekeeper, and it was a DOC determination as to where he went and what his restrictions were. So she is not in a position to answer that, and I don't think it should be asked. In conjunction with that, during deposition and the 3-day hearings, there was discussion. That whole 3-day hearing, by the way, I read through the transcript on my page. If you go search under all things Delphi, there's a folder, and that 3-day hearing is somewhere there. That particular policy has been addressed by defense in multiple settings, deposition, and at that hearing. It does not apply to Mr. Allen. It's a legal determination by the DOC, and as a safekeeper, that policy does not apply to him, so she's not the appropriate witness to answer for DOC legal determinations. We do have Elise Gallagher here, who's the something for the DOC, if additional insight on that particular issue is helpful for the court, but we're asking for a motion in limine, order in limine on those related topics. The court says, okay. Mr. Rosie says, what was the first one? I'm trying to recall. Ms. Diener says, impeachment by making reference to the fact that she had a gate closure. Mr. Rosie says that was the second issue. Ms. Diener says that was the first, safekeeping. Ms. O'Shea says Keegan Klein's incitement or incite search. Mr. Rosie says, "Oh, okay." Ms. Diener says impeachment. It was also the Keegan reference because that's what she looked at and she told you she's not going to lie about it. Mr. Rosie says, "About what?" Ms. Diener said she didn't lie about using it. She volunteered that information in response to a question. Mr. Rosie says, "Okay." Safekeeping, so the insight search there was an admission by her that she didn't read it. She didn't copy it outside of the scope of an employee for personal reasons that involved this case. Facts and circumstances, something something, it doesn't necessarily, bringing it up doesn't mean that we use it for impeachment purposes. I think it's good for the jury, the story behind really the backstory, which she later reported it in court. So I think it's relevant and it doesn't necessarily need to be in a formal impeachment. It's just what she did and what she knew, what she learned through insight, all of which she eventually reported. And remember, this is a case too where she destroyed her session notes after she prepared them, despite the fact that their policy suggested and tells us that she keep them. I think it's relevant. I'm not sure that it's an impeachment issue in the first place, and that's my response to that. So she destroyed her notes. So I wonder if there was anything in her notes about this Keegan Klein and the Insight search, perhaps. Or worse, maybe stuff about what she was telling Alan or trying to get Alan to say if she was trying to coerce something out of him. Ms. Diener says, I would respond that none of her records does she make reference to checking Insight for Keegan Klein. That appears nowhere. I've been through every page of her report. It doesn't exist. If it does, I'd like to know where it is. And with regard to, I'm sorry, I just lost my train of thought. I'm so sorry. The court says, so she accessed information. Ms. Diener says, and it wasn't about this case, it was about Keegan Klein's. The court says extraneous information. He was separately charged. He was discovered through this investigation for possession of child rhymes with corn and child solicitation. Hold on one second. Sorry, I got a call, a doctor appointment confirming a phone call for me. All right. So Ms. Diener says he was separately charged. He was discovered through the investigation for possession of rhymes with corn and child solicitation. The court says okay. Ms. Diener says so connected to the investigation, but not Richard Allen. But it is because he was searched, he was looked into as a suspect in this case. So it is relevant. Mr. Rosie says, I have no intentions of, I'm sorry. Mr. Luttrell says, the point is, Your Honor, it's improper impeachment. You cannot try to impeach a witness on a specific act or misconduct unless it's a criminal conviction, which this certainly is not. This Truesdale case, Your Honor, is instructive. The Indiana Supreme Court about a psychologist who, or a medical doctor that had their license actually put on probation. The status of his license was relevant, but the reason behind it is irrelevant because it became a violation of something. And this is specific and it lays out specifically a specific act of misconduct. The bailiff says, Can you guys quiet down? We're on the record. Thank you. Mr. Luttrell says, To go with character or truthfulness are not permissible. If there's any other reason, then, Judge, it's irrelevant. So I think they should fail on the issue of why is she no longer working in Westville. It is irrelevant and it's improper impeachment. Ms. Diener says, I just remembered my thought, Judge. He makes reference to the APA best practices, but those are not DOC policy and they are not Centurion policy, so I don't have a problem with asking her that. But this is not the policy of her employer or of DOC. Mr. Rosie says, You can't sit here and say this policy doesn't apply to one case and then it does in the other. The court says, I think the policies of the American Psychological Association. Mr. Rosie says, Yeah. The court says, I think those are fair game. She is a psychologist. I don't think we need to get into the meetings like we did during that hearing. Mr. Rosie says, Yeah, I have no intention of doing that. The court says, but I think that it is fair game, that she should be allowed to acknowledge or disavow knowledge of those particular practices. But I don't think the search that she did, I believe the fact that she did a search, if you get her to it, but not who or Mr. Rosie says, I wasn't. The court says, anything else? Mr. Rosie says, I wasn't gonna. The court says, I mean that she accessed a DOC website to obtain information about this case. That is not professional. Yeah, I don't have a problem with that. Mr. Rosie says, that's my intention. The court says, but that's as far as it goes. Mr. Rosie says, I can something. These inaudibles are ridiculous. There's so many of them. Ms. Diener says, okay. The court says, okay. That's as far as it goes. Mr. Rosie says the safekeeper status, so the relevance of her talking about him keeping a or being a safekeeper as it relates back to the policies on how they treat people in solitary confinement. Safekeeper is a designation, it's a term of art in those policies. If you're designated a safekeeper, there are certain ways that you're handled down in DOC. I am fully prepared that they're going to make the argument that this guy was different than everybody else and that they had the right to keep him in solitary confinement forever if they wanted to. Wow. Should they, though? But she has testified that the purpose behind the 30-day rule, the solitary confinement rule in the policy, is to protect somebody from mental health standpoint. And I think that's, the court says, and does that apply to a safekeeper status? Mr. Rosie says yes. Ms. Diener says it does not. And Elise Gallagher is here to tell the court, if need be, that the DOC 30-day SMI policy for confinement does not apply to safekeeper. Safekeeping status trumps. But for the safety of the uh, inmate, or I guess he's still an inmate, he's not convicted. He's an alleged murderer at this point. He has no convictions at this time, and yet they're just keeping him in solitary confinement indefinitely. Mr. Rosie says both Dr. Walla and Dr. Dwenger, who was the head of behavioral health at DOC until I guess I just learned this morning, she something something, both of them testified in depositions that the purpose of the 30-day rule is to protect somebody's brain. It's to ensure that, yeah, and why aren't you protecting Richard Allen? He needs protection too. It should apply to him too, not just whoever you want it to apply to. This is ridiculous. The court says, well, and I don't have a problem with you getting into that to that extent, but we're not getting into safekeeper. That policy doesn't apply to a safekeeper. I'll give you a little bit of a leeway to inquire as to the 30-day policy, but we're not going into it in its entirety because it doesn't apply. Mr. Rosie says, well, the court says, in this particular situation, I realize you disagree. Mr. Rosie says, yeah. The court says, with that, and you're entitled to ask her that narrow question, specific question, but DOC policy does not apply in that regard to him, and I don't have a problem with that coming out. Mr. Rosie says, well, but the DOC policy, just to make sure we're on the same page, does apply to all of them as it relates to why they shouldn't be in solitary confinement for 30 days. It applies to all of them. There is Ms. Diener says, Judge, the question of how this is related to, it's for the jury to decide how much weight they give this. The question isn't whether they were voluntary. They can argue all sorts of things about the voluntariness. Court says, absolutely. Ms. Diener says, or not, involuntariness of his confessions, but what the DOC policy is about, who's an SMI and how long they can stay in confinement doesn't really equate to that. He's in solitary. Mr. Rosie says, if you're going to be maintaining an environment that's not consistent with your policy, then it's relevant. Mr. McLeland says, but the policy is trumped by the court order. Why? And who says that? Who says it's trumped by the court order? Why are we keeping him there indefinitely? Why are we not reevaluating the court order? Is my question. Why are we keeping him there so long? Court says right, and that's the issue. He's a safekeeper, so the policy doesn't apply to him. I didn't have a problem with, and I assume you have a witness that you're going to talk to the effect of solitary confinement on humans? And Mr. Rosie says, yeah. The court says, and how long? And that is fair game. But the policy itself, that doesn't apply to him is not. I think we're getting into the weeds with that. Mr. Rosie says, that's their words. You're just because they put something that doesn't mean it doesn't apply. They have admitted that it applies to humans who are locked up for more than 30 days. They have admitted that across the board. The court says, okay. If you don't hate Judge Gull by now, you should. She does not care. She was like, yeah, and so? Mr. Rosie says, so I think that that's permissible. I mean, I'm not in here arguing an administrative law case that they should be held responsible, the DOC, because they violated some policy, which they did. The question is what's the impact on our guy? The impact. Ms. Diener says, you can talk about the impact without even talking about the policy. Court says, exactly. Ms. Diener says, that's your whole point. Mr. Rosie says, well, no, because that's, Ms. Diener says, your whole point is, Mr. Rosie says, sets the foundation for. Ms. Diener says, is that the whole point is that his circumstances are these circumstances, and they have caused him to make a confession that's not reliable. It doesn't, Mr. Rosie says, based on something. Ms. Diener says, what the policy is. The court says, well, whether there's a policy or not is not the point. The point is you have witnesses that are going to testify about the effects, and that is important for this jury to know. Whether there's a policy or not is not important for the jury to know. Mr. Rosie says, well, it does set the foundation as to what they're going to testify about. The court says, well, I understand that, but I'm going to give you some leeway when getting into that with your witnesses, your other witnesses. Ms. Auger says, can I ask a clarifying question? So, is he allowed to ask if is there a policy, but it doesn't apply? The court says there is a policy that applies to the Department of Correction. That policy does not apply to Mr. Allen. Yes. Ms. Auger says, oh, okay, I just wanted to. The court says, and that's as far as it goes. Ms. Auger says, okay, okay, thank you. What's the next one? Ms. Diener says, that's fine. That's it for me. The court says, okay. Mr. McLeland says, Judge, I have a totally out of scope question. Is there going to be a time limit on closing? I'm just trying to look ahead. 2 hours, says the court. Mr. Baldwin says, Mr. McLeland says, Mr. Baldwin mentioned that okay, 2 hours. Perfect. Okay, thank you, Judge. Mr. Rosie says, I'll use this sidebar just to renew all of my objections with regard to the admissibility of Dr. Wallace's statements in terms of what Rick said, the statements that she's going to testify to based on everything that I argued before in the July and August hearings, July 30th, 31st, and August 1st. Ms. Diener says 31, I think. Mr. Rosie says, so something in that area. Okay. Mr. Rosie says something, but we don't get to hear it. The court says, because, like I said in my ruling, all of her extraneous, the internet search, the walking on the trail, all of that came in during the hearing. She walked on the trail. I forgot about that. She walked on the trail. That impacts her credibility, and you are entitled to go there. Mr. Rosie says, yeah. The court says, I mean, we don't have to beat a dead horse. Mr. Rosie says, no, I know. You've been beating a lot of dead horses, says the court. No, he hasn't. He has barely been able to get into anything because of his limitations by the court. You're beating a dead horse? A lot of dead horses? Get out of here, Judge Gull. Mr. Rosie says, I think the jury's going to expect it. That's my opinion. So it's an exhaustive amount of information. The court says, okay, what else? Mr. McLeland says, give you a preview for the day while we're here. Court says, okay. Mr. McLeland says, because I know you asked for that. During the process, Dr. Walla, we may have a short witness after Dr. Walla, and then we'll have Brian Harshman in, and then rest. So Brian Harshman went through all of the confessions and everything and compiled them, I think. He listened to all of the recordings and stuff and compiled all of the times where he confessed on his phone calls to people. So that's going to be the end, I guess. The court says, okay. Mr. McClellan says the problem with Harshman is he's going to be introducing the phone calls, and we've got we've got at least 2 hours of phone calls. The court says, okay. Mr. McClellan says, and so if we get to 2 or 3 o'clock, I really don't want to split him up. But again, that if we get to 2 or 3 o'clock, we may be in a position to say, okay, Judge. The court says, and a lot that's going to depend on cross. Mr. Rosie says, yeah. Mr. McClellan says, absolutely. The court says, and the breaks that we'll be taking. So, Mr. McClellan says, and so I'm just giving you a heads up that we, uh, that if we get late in the day, I may be in a position to say, hey, Judge, can we recess till tomorrow? The court says, yeah. Mr. McClellan says, uh, tell me what you want me to do, and I'll have Harshman here. The court says, well, and it might be, I think the jury, we kept them late yesterday. Right, says McClelland. The court says, they probably would appreciate. McClelland says, yeah. A little bit more, McClelland says. It's going to be 2 hours of phone calls at least. Okay, says the court. McClelland says, and then my direct, his cross, and Harshman's obviously an important witness. Yeah, says the court. McClelland says, because of the confession. So it's gonna take a morning or an afternoon. The court says, okay, to get it done. So just a heads up, Judge. Court says, all right. Just for clarification on her employment, Rosie says, on her employment situation, I'm not sure we covered that entirely. There was a gate closure. We've seen that that's not something that was clearly related to her use of personal activities while at work, whether or not she conducted an insight search or I don't know that I remember exactly what she said she did, but she admitted in court she stepped outside of those boundaries. The court says, mm-hmm. Miss Rosie says, and so I am permitted to just point out to her that that's why she was terminated. Ms. Diener says she was not terminated. The court says she's not terminated. Ms. Diener says, and the gate closure did not say why. Mr. Rosie says, there's been no evidence of that. Ms. Diener says, the gate closure did not show why, and you subpoenaed the employment record, and there's nothing in there about the reason for the gate closure, and it does not. Mr. Rosie says, well, Deanna Dwanger said that's why. She can. Or Ms. Diener says, well, then call her as a witness. I'm going to, says Mr. Rosie. The court says that's just character assassination. I mean, she worked for Centurion at DOC. She is no longer working for Centurion at DOC. Because of her actions in this case, woman. It's absolutely relevant. Mr. Luttrell says, it's improper impeachment of the witness. I'm sorry. The court says, no, it's not. No. Mr. Rosie says, doesn't that go to her work product, like the quality of her work product, which is credibility? The court says, it goes to, Ms. Diener says, she told you she did the search. Yeah. Ms. Diener says, sorry. Mr. Rosie says, what's that? The court says, no. I mean, she told you she did the search. I don't know the reason, and honestly, I don't even know what a gate closure is. But the fact that she wasn't fired, no, we're not getting into that. She's not working there anymore. Yeah, that's a fair game. You're not working there anymore, and the jury can draw their own inferences as to why she's not working there anymore. Okay, we ready now? Mr. McClellan says, yes, Judge. Mr. Rosie says, yes, ma'am. Court says, okay, perfect. The sidebar conference was concluded, and the court says, all right, are we ready to bring in the jury in? Ms. Diener, she says, yes. Mr. Rosie, yes. All right, gentlemen. The bailiff says, all rise. The jury comes into the room. The bailiff says, thank you. You may be seated. The court says, thank you, gentlemen. Well, good morning, ladies and gentlemen. It's nice to see you back this morning. I hope you had a pleasant evening. I know you didn't have much of the afternoon yesterday. You had an evening. Anyway, again, as we parted company and you've had access to your electronic devices for purposes of work and contacting your family, I'll just ask again The following series of questions. Ladies and gentlemen, have you read, seen, or heard any media accounts concerning this case? All jurors answered in the negative. Have you discussed this case with anyone? All in the negative. Have you permitted anyone to discuss this case with you? All negative. Have you conducted any research into this case? All negative. And finally, has anybody persisted in attempting to discuss this case with you? All jurors respond in the negative. All right, ladies and gentlemen of the jury, I appreciate your continued compliance with the court's orders. I apologize for the little brief delay that we had getting started, not quite at 9 o'clock. I had a matter I needed to attend to, but we are ready to proceed. Ms. Diener, you may call your next witness. The state would call Monica Walla. The court says, are your microphones on the table? Thank you. Sorry. Ms. Augier says, sorry. The court says you may proceed, Ms. Diener. So we're going to stop there for today. And next week we will proceed with Dr. Monica Walla. She, again, the psychologist. This is going to be a good episode, or it's going to be a couple episodes. It's going to be 2 or 3 episodes for her, but you're not going to want to miss it because of the controversy that is Dr. Monica Walla. So stay tuned. Make sure you are subscribed. Hit the like button. Share this video. Comment. Let me know what the craziest thing is about this case that you can't believe. All those YouTube things. And I appreciate it. I appreciate you guys for watching. Thank you so much. And I will see you in the next week's episode. Take care, guys. Bye. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.